Hi everyone, I am Prativa Bista and my student ID is GCV2046. Today me and my friends are making a video presentation for Business and Corporations Law H16027 S3 group, and my group number is 4. We have 5 members in my group including me. The other 4 friends are Nirma Tamang, Anjana Adhikari, Manisa Mahajan and Jyotsna Khatiwada. The topic for our assignment is Forrest versus ASIC 2014. Regarding the introduction of the topic, Fortescue Metal Group is an iron ore company owned by Mr. John Andrew Forrest, who is the chairman, CEO, and substantial shareholder of Fortescue. The Australian Securities and Investment Commission ASIC on March of 2006 raised allegation against Fortescue, claiming that the framework agreement made by Fortescue with 3 state-owned Chinese corporations were deceptive. ASIC claimed that there was no binding contract and the agreements were precarious and was not legally enforceable. ASIC also claimed the claims made by ASIC were declined by Justice Gilmore on trial, but the full court of federal court accepted that the appeal made by ASIC, and thus ASIC was successful in achieving orders that Fortescue is involved in deceptive conduct in the contravention of Section 1041H of the Corporation Act 2001. Continuous disclosure requirements contained in the Section 674 of the Act has been breached by Fortescue, and there was failure to fulfill promises in the contract which compromised the Section 181 of the Act. Further, Mr. Forrest appealed to High Court, and the High Court stated that Fortescue of Mr. Forrest had not been involved in any kind of deceptive or misleading actions regarding Corporation Act, as there was no any evidential basis for assuming that any person hearing or reading the statements would comply that the parties were part of any agreements that would be enforced by the Australian law. Thus, the High Court dismissed the orders made by full court of federal court and reinstituted the primary judge's decision that Mr. Forrest had not infringed the Corporations Act.
In the second part, I am going to talk about the duties and responsibility which were breached. During the month of March 2006, ASIC brought minute stating that FMG is involved in misleading and deceptive conduct under 1041H of the Corporation Act 2001 by dishonestly demonstrating to investing public that the framework agreements were enforceable contract to construct, invest the railway and the port and the mine. Therefore, ASIC decided to place its case of contravention of 674 of the Act in various ways in the Federal Court of Australia. Firstly, it stated that FMG failed to reveal the terms and condition of the real meaning of framework agreement. Secondly, ASIC stressed that FMG to comply with 674 breached the provision by making incorrect disclosure. Lastly, ASIC emphasized that FMG breached 672 by not correcting false and misleading information as to the terms of framework agreement. The hearing judge terminated the claims that was made by ASIC. However, the full court of the federal court allowed ASIC to make appeal and make decision that Fortescue have been involved in misleading and deceptive conduct and Mr. Forrest was unsuccessful to discharge his responsibility as a director. Full court gave its decision that because the agreement would be enforceable under Australian law, this was misleading to define as binding contract. With special request, Fortescue and Mr. Forrest appealed their case to High Court. The High Court focused its inquiry on whether Fortescue mentioned the term binding contract in the agreement was misleading or likely to mislead. The court performed close analysis regarding the term binding contract. However, it can be said that trial judge gave more focus on disclosure of the effect of framework agreement than actual term. After hearing and reading the agreement that the Fortescue and Chinese contractor enter into the agreement that each one intended to be binding, the court disagreed with ASIC term binding contract. The contract involved foreign state-owned entities which were based in China did not concern the choice of forum. ASIC also claimed that the Forest tried to modify the terms of framework agreement, but court rejected this argument. High Court found that Fortescue had not been involved in neither misleading nor deceptive conduct. Furthermore, as the statements were not misleading and deceptive, court even found that Fortescue and Mr. Forrest were able to meet the obligation under the Corporation Act. Therefore, federal court kept aside federal court decision.
Hello, I'm Jyotsna Khatiwala and my strain ID is PVS2087 and I'm going to explain about the analysis part of the case. In this case, the court has held the decision in favor of Fortescue Metal Groups Limited and Andrew Forrest unanimously in connections with the public statements about agreements made by Fortescue with 3 Chinese state-owned entities. In this case, Fortescue and Forrest are the appellant and Australian Securities and Investments Commission is the defendant. The appeals of ASIC had been dismissed by the trial judge, which however was allowed by the full court of the federal court and made declarations that Fortescue and Forrest had contravened the provisions of the Corporations Act 2001, to which the appellant appealed to High Court against the decision of the full court of the federal court. In the case, Fortescue had made agreements with 3 Chinese state-owned entities headed as framework agreements. These agreements were concerned building and financing services that were to be provided in connection with Fortescue's Pilbara iron ore and infrastructure projects. The public announcement made by Fortescue and Forrest was the Fortescue had entered into a binding contract with each of the Chinese entities. However, the terms of the contract lacked certainty and the agreements would not be enforceable under Australian law, and in light of Section 1041H, which prohibits from the engagement in the conduct in relation to a financial product or financial service that is misleading or deceptive or likely of such. ASIC commenced proceedings in 2006 and they were of the view that Fortescue and Forrest had engaged in misleading and deceptive conduct when they represented that the contract were binding. Further, ASIC alleged the continuous disclosure requirements contained in Section 674 was breached by Fortescue and Forrest as they had not corrected the misleading information. Also, Mr. Forrest was alleged for the failure to exercise his powers and discharge his duties with the degree of care and diligence as required by the Section 180 subsection 1 of the Corporation Act. The High Court focused on whether Fortescue's use of the term binding contract on the announcement was misleading or deceptive or likely to mislead or deceive, and conducted analysis of the meaning of that term was as understood with reference to intended audience. The court held that the statements made by Fortescue and Forrest represented that the 2 parties to the contract, that is Fortescue and the Chinese entities, had entered into agreement that each intended to be binding. This wasn't a misleading representation. The court held that there wasn't any ground for assumption that any person would read the agreement would think that the parties had entered into agreement which will be enforceable in the Australian court according to Australian law if any dispute arises. Thus, the statements were neither misleading nor deceptive. In the same manner, Fortescue and Mr. Forrest hadn't contravened any provisions of the Act. Therefore, the High Court overruled the full court's decision and held the decision in favor of appellant. My friend Nirma will further explain about the reasons for the decision.
The 4th party's reason for decision. This petition started after the incident happened in 2004 and 2005 related to the mining project about a railway which was building to connect the mine to the port in Western Australia, and Fortescue Metal Group Limited is a publicly registered company on the Australia Securities Exchange. Also, they planned that the plant would consist of mine in the Pilbara region. The company got alleged from ASIC that it involves in conflicting behavior with the Corporation Act 2001 in relative disclosure of FMG's project. FMG and Forrest had argument with Chinese companies in 2004 regarding the construction of the mine, port, and railway. Hence, the decision discussion ended with the execution of 3 contracts with China Metallurgical Construction Corporation, China Harbor Engineering Company Group, and China Railway Engineering Corporation, along with Chinese contractors. While these arguments are regarded as framework arguments, also the agreement with these 3 groups was confirmed on August and October 2004 respectively. In August and November 2004, 3 news about project was released through media to the Australian Stock Exchange Limited by FMG, and they are the news about CREC agreement released in 23rd August 2004 through later. The media regarding the CREC agreement and CMCC agreement announced on 5 November 2004 and on 8 November 2004. The letter was sent from FMG to the ASX, including all 3 framework arguments, which was proposed for the project to construct, invest, and move the railway, port, and mine. Furthermore, this info for the project to construct, invest. Furthermore, this info was recorded in the appendix and tagged, as well as repeated and published in number of publication in FMG. In 23rd August 2004, Forrest said the value of the railway line was publication by FMG. The value of railway line was confidential, but was pleased to say it is competitive. Hereafter, the announcement was made by the press conference, but notice were given on 23rd of August and November 2004 by FMG by the press conference, but FMG demanding trading breaks, which helps to boost the price of shares during the period of from 59 cents to $5.50. In March 2005, an article was printed in the Australian Financial Review mentioning the framework agreements did not impose any legally binding obligation on the Chinese contractors to construct, invest, and move the railway, port, and mine. After the publication, the share price also fell down, but the closing price has improved at 23rd March 2005. Now my friend Monisha will continue the impact of the decisions.
Thank you, Nirma. I'm here to explain the conclusion. However, the regulator did not succeed in their task to preserve the attraction in Forrest versus ASIC. The ASX also became unsuccessful to enforce timely compliance with the continuous disclosure regime and ensure that the marketplace was well enlightened by pursuing present classification from FMG as to a great stable place and or seeking production of a copy of the CREC agreement. Well, ASIC was unable to succeed in the High Court just because of the way it implored its case and did not pursue the competitive price representation, while it was dynamically arguable that the competitive price representation was deceptive or suspicious or imaginable to mislead or deceive. While building the knowledgeable base case of the individual is in misleading and deceptive conduct cases, implicate public affirmation is probably an argument of fact for the court, and also it requires the drawing of inferences from the verification led by the different parties. Somehow it will be very difficult in determining whether the challenge statement has its tendency to lead an appropriate reasonable member of the target audience into error. However, the High Court majority's criticism of ASIC from failing to lead evidence that some investors were actually misled by the binding contract representation suggests that in future a new evidentiary requirement is being imposed under the Campomer test. Well, as it was pleaded by ASIC, the High Court did not have to consider the competitive price description. It had also declared that FMG and Forrest had not engaged in misleading conduct in relation to the binding contract representation. The intended public could have explained the impugned statements as statements of the parties intent as to what would happen under the CREC agreement. It had no implication for the direct legal effect of the agreement if the parties sometimes fell out in the upcoming time. The verification of 37% fell in the FMG share price in 2005 March, backing the publication in the Australian Financial Review asserting the CREC agreement did not enforce legally binding obligation on CREC. This is somehow very surprising. Almost all the Australians are somehow forced to expand in companies which are listed publicly because of the compulsory superannuation system. Coherence and sincerity of Australian capital markets by ensuring fairness of opportunity for investors through public access to accurate and material company information to enable them to make well-informed decisions is the main policy of the misleading and deceptive conduct provisions in the Corporation Act and the continuous disclosure regime. Lastly, the legislative approach adopted by the High Court in Forrest versus ASIC seems to promote a caveat emptor approach to investment in our capital markets. A significant body of shareholders might not be judicious and courteous as assumed by High Court. Thus, we would like to end our case discussion here. Thank you.